Good morning, Your Honors. My name is Allison Perry, and I represent the appellant Elizabeth Nelson Hudson, the former wife in this appeal. I would like to reserve 5 minutes for rebuttal, if I may.
Yes, ma'am.
I would first like to apologize to the court because in my brief, I stated that the former husband did not plead for majority time sharing when on page 35 of the record on appeal, he did plead for it. However, at the beginning of the final hearing, his attorney stated that what the husband wanted was for the wife to move back with the kids and them to resume a 50-50 time sharing. And he also said at the end of the
But that would have been prospective if and when she moved back.
well, she said she was going to do everything in her powers to move back. I don't know how the court found that she had no intentions of moving back under this record.
Well, because the court made some credibility assessments, and candidly, we've been there before where we hear a litigant saying, oh yeah, I want to do my best to do this. And maybe we don't, as triers of fact or even as attorneys, maybe we don't really buy that they're going to do their best or that they're actually going to follow through. Couldn't the trial court in a position to make that kind of call?
But the court said she stated she had no intention of moving back, but she did in fact state that she intended on moving back.
Going back to what I said before, and sometimes we don't have to believe what people tell us, right? I mean, just because somebody says, yeah, I intend to do this as triers of fact, we don't have to take that as gospel, do we?
Well, that's a position that you can take, and the court can take, because they are the credibility determinator. So,
Well, didn't you say it won't be anytime soon? I mean, she made it clear it would not be immediately in that she would.
well, she had to get housing.
So
yeah.
even if we may tinker with the trial court and its assessment, its ultimate assessment that she had no intention, can we say it's an abuse of discretion to have included in the order what was included pending a future change in her relocation? Well,
The reason that we wanted the close range parenting plan is because to show a substantial change in circumstances, if she moved for a modification instead of having it in there, you have to show a substantial change in circumstances. And there's all this case law out there that may become obsolete because of what's on the governor's desk right now. But it states, all the case law states that a parent moving is not considered a substantial change in circumstances. So she's in between a rock and a hard place because everyone knows or says she said she was going to try to move back. She was going to do everything in her power to move back. So it's something that's known at the time of the final judgment.
But to some extent, didn't she create the rock and the hard place?
Well, she created the rock in the hard place because her husband put her under a rock. Because he said he was ordered to pay all the housing bills for the wife.
There were other options that she could have.
She went on welfare. She got food stamps. She got the kids a Medicaid. She was bending on she was almost homeless. So she had to go,
And we understand all that. We've read the record. There's no great actors. Nobody's going to leave here today with a commendation for the way they handled themselves. But you're talking about a rock and a hard place that she created by upping and moving, 4 or 5 states away without any notice when she was required to give notice.
Now, she didn't give notice, once again, bad behavior, but this is after 3 years or 2 years of the husband not paying the bills he was supposed to pay.
So we're supposed to start applying a 2 wrongs make a right standard?
That's a very good question, Your Honor, but I'm just saying that she got in the hard place because she was actually like under a rock when she was in Tampa. Because he was not abiding by the court order to pay the temporary housing and living expenses of the wife and the children. He didn't pay any child support during the 3 years of the litigation. He told the wife when she asked for help with diapers, go to a church organization. I mean, so basically, the bottom line is she wants a 50-50 time sharing schedule and to be able to get that without having to go through a modification.
Well, let me
petition.
ask you to kind of go beneath the bottom line, the double bottom line. She lives in West Virginia. She has no place in Florida. How is a trial judge even supposed to make that happen without uprooting kids from school at different points?
Well, the way I've seen it done in other cases is if the wife moves back within the area, within the next 60 days, the parties will go to a 50-50 schedule. We'll resume the 50-50 schedule.
So what you're really
That's
asking, what you're really asking then is an unequal, and I'm not sure I saw this in the briefing, but an unequal schedule that reflects the fact that one's in West Virginia, one's in Florida.
Yes,
But in the event wife carries through with her stated intention of coming to Florida, then it switches to 50-50.
exactly.
And it was an abuse of discretion for the court not to have entered that as a parenting plan.
Well, that's my argument.
Okay.
So, and then as far as the child support goes, there were 22 months that was not awarded of retroactive support. And part of the reason that the court didn't award the retroactive support was based on the wife's bad behavior. And you don't sanction children for their parents' bad behavior.
But it was made up in some other areas.
Well, they did an unequitable distribution, so.
Which, as you know, is hard to get.
It is hard to get, but child support should be separate and should be away from the equitable distribution issues. And the unequitable distribution was based on the husband's waste also, because he had a propensity to visit massage parlors. So the court found that that was marital waste and that she was entitled to an unequitable distribution. So, are there any other questions? I'll reserve my time. Thank you.
Your Honors, Megan Howell on behalf of the appellee. So I wanted to first start by addressing the only issue in appellant's brief that I believe could have some potential merit and why I believe that that still fails here today. And that would be the retroactive child support argument. So appellant's argument is that the retroactive child support should have been paid for the full time that the parties were separate instead of for the 13-month period that the court awarded. In the paragraph in the final judgment before the trial court addressed the retroactive child support, it did note that it struggled with the financial determinations because neither party was forthcoming with their financial information. So I think that both parties' conduct definitely contributed to the trial court's determination in this matter. But the issue with appellant's argument is that while the guidelines for ordinary child support in Florida are presumptively establish an amount for child support, the retroactive child support is left to the discretion of the judge. So there are some factors that the judge must consider in determining the amount and whether retroactive child support is appropriate. There are three under Florida statute 61.30. The first one is the party's income, whether that be actual or imputed by the court. The second one is all payments made by either party for the benefit of the children during the retroactive period. And the third one is whether a payment plan would be necessary to do the retroactive child support. I think here on an abuse of discretion standard, it's clear that the court went in detail through each of these factors that it was required to go through. So the appellant can't meet the burden of an abuse of discretion. The court considered all of these factors and found that the father's income was imputed to be $133,000, that the mother's gross actual income was $62,000 per year, that the mother pays the children's health insurance expenses, that the father owes the mother $1,200 for unreimbursed medical expenses, and that the trial court actually also set a specific payment plan so that the father could become current on his arrearage and child support. So each of those is those prongs A through C that the court determined pursuant to the statute. But the court didn't only consider those things because it's discretionary. The court considered the mother's bad faith relocation without notice to West Virginia, and also the unequal distribution in favor of the mother, which was that the father took on all of the debts and the mother got more money from, and the proceeds from the father's portion of the house went to her as well. And to address the argument that the children shouldn't be punished by, you know, the parents' bad actions, I think we can all agree that that's a solid premise. But I don't think the children were punished in this case because the father does have majority time sharing in Florida, and so her childcare obligations are lessened significantly because the father is taking on roughly 75% of the children's, you know, living and all that other stuff. So I would just state that the appellant has failed to show an abuse of discretion by the trial court. As to the lack of notice as to the majority time sharing, I think we already kind of addressed it. I would just say that just because he was willing to do 50-50 by the end, if she moved to Florida, doesn't negate that he pled for majority time sharing, and that was something that the parties could expect to be awarded in this case. So I would say there's no lack of notice, and on de novo review, no due process violation occurred. As to the actual time sharing, which was the substance of the time sharing award, which was majority, it's also an abuse of discretion standard, and the courts have said that the decision has to be affirmed unless no reasonable person would take the view adopted by the trial court as to what percentage of time sharing goes to which party. In this case, the court considered extensively what would be in the best interest of the children based on the dissolution proceedings, and also based on the children's lack of ability to adapt to life in West Virginia. The children didn't adjust well and had behavioral issues in school, threats of self-harm, and were being held back. So the court found it was in the best interest of the children that they live in Florida, where they were well adjusted and where they did have a stable home. And in moving to West Virginia, the wife took herself out of Florida, so it only made sense for the trial court to award majority time sharing to the parent in Florida because it's in the best interest of the children to live in Florida. So I would repeat that the court didn't abuse its discretion in awarding the majority time sharing. And then finally, I touched on this in the brief a little, and your honors touched on it a little bit with the appellant, but the mother invited any of the errors that she now claims the trial court made with her behavior, and both parties had abhorrent behavior, I think, throughout the proceedings, but the things specifically that the mother is appealing, each decision that the trial court made, it factored at least in part the choices that the mother made. So she cannot now benefit from those choices on appeal. Does the court have any questions?
No, ma'am.
Thank you.
Thank you. There you have your full 5 minutes.
I just wanted to point out to the court that the 22 months that the mother did not receive child support, she was unemployed. So the husband was making $130,000 a year, and the wife was unemployed. She had been a stay-at-home mother by agreement of the parties. And he provided absolutely no support during the 22 months. And like I said, you cannot punish the mother because of her bad behavior by taking away child support. That's not appropriate. And then I'd also like to congratulate Megan for, this is her first oral argument.
Thank
Very
you.
well.
So, good job, Megan.
Thank you.
Thank you both. We'll go ahead and call the next case.
Thank you, Your Honor.